Okay, hello everyone. Uh, just about to start the KLP talk, What About the Kids? Just so that I can make sure that the technology is working, there should be a button on your handset or on your PC which says raise hand. If you could please raise your hand if you can hear me and if you could also see my screen. So if I can get you all to do that to make sure that everything is working as it should. Okay. Excellent. Okay. It's looking like it is working the way that it should. That's fantastic. Okay, so let's get started because I've got a fair bit of content. So who am I? I'm Kate Pateman. I'm the founder and director here at KLP Family Law. We're a boutique family law firm, and that's pretty much all that we do. So we're quite specialised. So the limitations of today. Just a quick overview. I can't give legal advice simply because this is very general matters that I'll be touching upon, and the main reason why I can't give legal advice is every matter is different. So not everyone falls into the same category. Now, the information obtained today is just the start. There is a lot of content, as I said, so if you do have any questions, please ask as we go, but it may be that if we get to the end, I'll answer them then, but if I can't, I'll certainly answer you in the follow-up email, so don't be afraid to ask any questions as we go. Okay, so what we'll be covering, have a look at that, so a fair bit. So things you need to know just after you've separated and whatnot, children care arrangements. I'll be talking about both what the law says, but also practicalities, because a lot of the times, despite what the law says, it doesn't transition into reality that well. We'll also touch upon DNA parentage testing, childbearing costs, location recovery orders, relocation cases, overseas travel, changing a child's name, adult child maintenance, breaches of orders, and ways to resolve your issues, and how to document agreements, and then where to from here. So a fair bit, not all of it will pertain to each and every one of you, but hopefully this overview will get you at least thinking about different ways to manage some issues that you may have in your new co-parenting relationship. So first off the rack, things you need to know. Most importantly, know where you are each at. And what I mean by that is, say you've just recently separated and you've been the one that has initiated separation. The other person may not be as advanced as you in what we call the grieving process. Sounds a bit weird, I know, but a separation, most people will go through a grieving process. They're grieving for the loss of the relationship. So here on this slide, I've given you a bit of an outline of the grieving process. So there'll be shock, denial, anger, bargaining, depression, and hopefully, eventually, acceptance. Now, just remember that this is not linear in the sense of it doesn't go in a straight line from shock, denial, anger, bargaining, depression, acceptance. Sometimes people will jump straight to the anger. Sometimes they'll go straight to the acceptance, but then they'll go back to the anger or the shock. So every person is different. So just be conscious of where your former partner may be in the grieving process. And I say that because if someone's in the anger stage, there's no point really talking to them about trying to come to settlements or resolutions about certain issues, because you may just get a knee-jerk reaction of no each and every time. So timing is really important as to when you have the conversations with them, but also how you have the conversations with them. And you know your former partner better than anyone else in the sense of, are they better verbally speaking to them, or would it be better to have it in an email so that they can have time in their own time to process what you're asking? So that's the first thing. Know where each person is at and how to interact with them if at all possible. Sometimes you get wild cards and you just don't know what's going on because the person's so all over the place. But just be conscious that they may still be going through the grieving process. And also there's no defined period as to how long that will take. Some people can take weeks, others months, some possibly years. I'm not saying wait until they're completely through the process, but just think about the timing of things. And the next thing in relation to practicalities is a holding pattern. A lot of people think, oh, well, we've separated, therefore things need to change, and they need to change now. I don't see the purpose in that. At the end of the day, you can take your time. Keep things normal. So with the finances, if pays go into a certain account, provided people aren't ripping the payout and splurging it, keep finances the same, because you may have house payments, you may have other payments. Who takes the kids to school and all those sort of things. So try, if at all possible, keep things what I call, inverted commas, normal. Strategically, and if only if it's safe, stay in the house. That if the relationship hasn't turned toxic, that might be good for the children. It may not be good for the children. So as I said at the beginning, every matter is different and every situation is different. And as far as possible, try and keep things amicable. So try and keep up the lines of communication. Be respectful of the other person, regardless of how they're treating you. Try and be the person that you want them to be. A lot of the times you can diffuse a lot of issues if you just hold your tongue, give them time, and then go forward. I don't like Facebook. I don't like a whole heap of text messages back and forth, back and forth. It's knee-jerk reactions. Try and stop that. So the next thing, and this is part of the reason why you're here in this webinar, make sure you get the information, advice and support you need before you do anything. A good analogy I always say is that you don't start building a house without first taking the time to lay the proper foundations. And that's the same for a separation. You can separate, but I mean, what you next do, make sure that you think about things, make sure you get the information that you need so that what you do will put you in the best position in moving forward. And lastly, remember the kids, okay? Sounds simple, but a lot of parents do get tied up in their own issues and forget about the poor kids and the effect of everything that's happening on them. And remember that kids go through different developmental stages, okay? So what might be good for a teenager is very different to what might be good for someone under 5 years of age. So with the developmental ages, and this is the solicitous psychologist trying to map their way out, but this is from studies and psychologists. Basically, for an infant to 5 years of age, they need a secure base in caregivers or family. That's not in location, so you don't have to be in the same place, but you need to have that secure base for them. They have very limited long-term memory and limited use of electronic communication. And they'll need shorter times away from the main caregiver, but frequent visits are needed with that other parent. Now, who is the main caregiver? It can be mum, it can be dad. I've had matters where either or are the main caregiver. Traditionally, it is usually mum, because mum is the one that will take the maternity leave off and spend those initial months with the child, and so they are considered as the main caregiver. But on the flip side of that, parental leave is open to men as well, and so I've had many matters where men will take months off to be that main caregiver for the child. So just take that into account. It's not leveraged against mum or dad, it's either or. Then from that stage, we get into the primary school years. So here their social networks are broadened. They can sustain longer visits, so school holidays, so block week times. Use of electronic communications is probably better than me. They have some capacity for independent travel. I think with most airlines it's the age of 12 or something like that, where they can have a hostess be their accompanying adult. And then from there you have the high school years. So with the high school years, the primacy of the social networks is pretty much a social capital. So for example, if they're wanting to go out with their friends, or if they've got a sporting commitment and it falls in your time and you're adamant, no, we're spending quality time together, that may backfire simply because that social network is very important to them, as are the social commitments. They also have the capacity to have independent travel and communication with the other parent, basically meaning that if you were looking at relocation, high school years are really the good part because they're more resilient, and hopefully the work that you both put into the care arrangements early on in their years will be all worth it at this developmental age. Now, hopefully, if technology has worked, you would have got an email with a workbook, and within that, it's got certain things about how to address issues or the goals that you're wanting to seek. So look to that. That's always great preparation. So I always say to clients when they come to me and they've got an issue, they usually give me the one option of fixing it. It's usually reducing someone's time or something like that. And I usually get them to pause and say, okay, let's look at least 2 other options because that is not the only option in most cases, and then we can evaluate those. So have a look at the workbook. It is good value, so the feedback has been, hopefully you'll get some value out of that as well. Now, children care arrangements. So let's have a look at what the law does not say. Okay, the law doesn't say, there's nowhere in the cases or in the Act that mothers get the children automatically. You hear that, oh, the law's leveraged against fathers and it's all for the mothers. Not true. That may be the media's perception, but remember, it is the media. They have their own agendas. Parents have no rights to children. In fact, it's the opposite. Children have rights to parents. Parents have responsibilities when it comes to their children. And shared care or shared time is not automatic. I know when the amendments were made back in 2006, the media again made it sound like the court must order shared care or shared time, and that's not true, and we'll go through that shortly. So in a nutshell, and we'll go through each of these steps in greater detail, what the law actually says. So there's a few things and there's a few steps, and there's one judge down in Melbourne who did a paper that says the easy 42 steps of how to decide a children's matter. So it can be quite convoluted, so I've tried to condense it here to make it make a bit more sense, I suppose. So the first thing is, the best interests of the children are the paramount consideration. So that's what the court will always look towards, no matter what sort of order that they're making. Then there's parental responsibility, equal shared parental responsibility, this equal time that everyone talks about, significant and substantial time, and reasonably practicable. So let's have a look at what each of those things actually mean. So best interests. Basically, like I said, it's the paramount consideration. There is a section of the Act, and if you Googled section 60cc of the Family Law Act, it'll come up with a whole heap of considerations or things that the court needs to take into account. And there's two primary considerations, okay? They're the ones that will really trump all. So the first thing is that every child has a right to have a meaningful relationship with both parents. And the second thing is that the court's obligation is to protect a child from harm or risk of harm, whether that's physical, sexual, or psychological. And then it goes on to have about 14 additional considerations that the court can take into account when deciding what's in a kid's best interest. And they range from a lot of things. It does have the wishes of the child. It doesn't have a specific age as to when a child can make a decision as to who they live with. It always goes on the maturity of the child. For example, you can have a 12-year-old that says they want to live with mum, but is heavily influenced by mum, so it's not their true wish. Or you can have a child that's 12 and is quite emotionally immature, and so their wishes may not get as great a weight. Then we look at, well, the practical side of things, like I was saying, the age of the children, the work commitments of each of the parents. So that's one thing that the court will take into account. If you're working 12-hour days, 7 days a week, the concern would be, when are you able to care for the children? So I do often talk to clients about, especially with young children, are they able to talk to their employer and see whether for a period of time they can tweak their hours. A lot of employers are really good with that, and some aren't, but it's always worth asking the question. We also look at the schooling or extracurricular activities of the children. So, for example, it may impact on things if changeover's on a Wednesday, so the kid needs to rock up to school with all their packed clothes and whatnot for changeover, but they've also got band practice and soccer practice or something like that, so they're having to take all these bags. They find it embarrassing to bring it all to school than having to collect it. And that is actually a true case that we actually had. It had nothing to do with mum or dad or the time that the kid was spending with either parent. It literally was the day of changeover, and we were able to change it to a Friday, and everything ran smoothly. So just think outside the square when you're thinking about things as to what is in children's best interests. Then we push on to this term called parental responsibility. Now, this is something that every parent has upon the birth of their child. So it's all the duties, powers, responsibilities, and authority which by law parents have in relation to children. That's pretty much the definition in the Act. Now, what does that actually mean? It just means that either of you can make any decision regarding your kids. The Act, the Family Law Act, actually takes it one step further and says, well, it should be equally shared parental responsibility, which requires you both, now that you've separated, to consult with each other in relation to the long-term decisions about the kids. And the court basically says, the Act basically says, you need to come to a mutual agreement. And if you can't come to a mutual agreement, then one party shouldn't be unilaterally making decisions. You need to go to the court and get the court to decide. Now remember, this is only for major long-term issues. It's not what your child eats or wears. It's in relation to the education, religion, medical, name changes, living arrangements, which would make it significantly more difficult for you or the other parent to spend time with the child. It does not relate to how much time a child will spend with you. Equal shared parental responsibility is just about the decisions you need to make for the child. So even if you get an order for equal shared parental responsibility, it does not automatically mean that there should be shared care or shared time. That is a presumption, that equal shared parental responsibility, and it can be rebutted or not apply if there's family violence, child abuse, or if it's not in the children's best interests. So, for example, I had one case many years ago where one parent was overseas and was not able to be contacted easily, and it was very difficult for the other parent to get agreements or have discussions with that other parent, and they were successful in getting sole parental responsibility so they could make those decisions by themselves. That parent, however, did include the other parent by email in certain decisions, but they were ultimately able to make the decision themselves. So if there's anything like that, the presumption won't apply. So what does that actually mean? Well, as I've said, it won't apply in those circumstances, but particularly because family violence and child abuse cannot just be an allegation, there needs to be evidence. Usually it won't apply, and same with family violence. Evidence is not just a protection order. Even though you may have a protection order, the family law courts may still determine that there should be equal shared parental responsibility. I know that when these amendments came in, you had a flood of people going to get protection orders in the state courts, but it did not necessarily rebut this presumption. So just be wary about that. If you think that's a tactical way that you can try and rebut that, it's not going to work in all cases. Now, if it's not in the child's best interest, these are some examples. Your communication is very, very poor. And I'm not just talking about difficult, I'm talking about very poor communication. Or if the parent's decision or position on certain issues places the child in danger, i.e. not agreeing to medical procedures that the child requires or medication, as I said before, living in different countries, radically different views about lifestyle, food, religion, or education, or if there's immunisation disputes, those sort of things, equal shared parental responsibility probably won't apply, but it may apply. It just depends on the degree or issues there are between you both. Now, thinking outside the box, this is an interesting one. A lot of people say, oh, there's some issues, we therefore can't have equal shared parental responsibility. I say, well, hold up. It may be that there's equal shared parental responsibility about a majority of things, but there might be one issue that is an actual issue. So, for example, if a child is diagnosed with a certain disorder or a disease and requires medication, but one parent doesn't agree with it and therefore refuses to give the child medication, therefore placing the child in danger, well, then one parent may have sole parental responsibility in relation to medical, but there's equal shared parental responsibility in everything, in relation to everything else like education, religion, and where the child is to live. So just think outside the square. Don't be boxing on one specific issue where you can actually agree on majority, and it's just that one specific issue that either needs a court determination or if you propose that they may agree. So when does parental responsibility end? Well, when the child turns 18, if the child marries below the age of 18, child's adopted, they'll actually extinguish all your rights in relation to a child. Or if it's terminated by a parenting plan or court order, i.e. that sole parental responsibility, or upon a death of a parent. Equal time. So this is what I was talking about before. If the presumption of equal shared parental responsibility is to apply, then the court must look at shared time or shared care. Now remember, I'm saying it's not that it must order, it must look at shared time. Again, the overriding principle is the best interest of the child. Other factors at play will be the age, so the developmental age of the child, where they're up to psychologically, developmentally, the work hours of each parent, and their ability to care for the child, those sort of things. Now, if the court is of the opinion no, equal time doesn't apply for whatever reason, the court must then look at substantial and significant time. And I'm saying the court simply because that's the yardstick, okay? It doesn't mean that you have to go to court. That's just a good indication as to what needs to happen. Now, substantial and significant time is defined like this: both days that fall on weekends and holidays, and days that don't fall on weekends or holidays, and allows the parent to be involved in the child's daily routine and occasion and events that are of significance to the child and parent. So that basically means any other time. There's case law that says every second weekend is enough for substantial and significant time. It could be that you have it so that it's 9 and 4, so 9 nights with one parent, 4 nights with the other. It's really what works best for you and your family that could fall under this. That isn't equal time. Then we've got this last thing that the court needs to look at, which is called reasonably practicable, which is a funny phrase, but it basically means that the court needs to look at things like how far apart the parents are to live from each other, the parents' current and future capacity to implement the proposed arrangement, capacity to communicate with each other, to resolve any difficulties, and the impact the proposal will have on the child and any other relevant matter. I was involved in a case many years ago where this specific phrase was the only issue on appeal, and it went straight to the, well, not straight, but it went to the High Court, and the High Court basically said that we need to have a look over and look at the bigger picture. Is the proposed arrangements able or practicably able to be put into place? In that case, actually involved mum's proposal that the child should live with her in Sydney and dad's proposal that the child should live with him in Mount Isa. And it was determined that the trial judge didn't actually look at the reasonably practicable issues, because if mum's in Sydney and the child ordered to live in Mount Isa, which the child was, it wasn't reasonably practicable for mum. But that case, listen, that was an issue in itself, because after the appeal to the High Court that mum made, she decided to stay in Mount Isa, and then dad decided he wanted to leave. So anyway, so that's basically reasonably practicable. It's just looking over whether it can actually be put into play. So what does that all mean for you now that we've talked about the law in a nutshell? It could mean a lot of things, and this is why this is quite general, but I say look to the workbook, simply because if you have specific issues, and usually you will, and those specific issues, not just, oh, my time with the child, nut it down. If your goal is, listen, I want to increase my time gradually because my son is 2 years of age, I want to increase my time gradually so that at the end we're having a week about when he starts school or something like that. And the other parent says, no, I don't want it to gradually increase to that, but I'll like it to gradually increase to, say, 4 nights a fortnight. That's your issue, yeah? 4 nights a fortnight vis-a-vis 7 nights a fortnight. So really what the issue is those extra 3 nights. So break it down, break the issues down. It's not usually as big as what most people think it is initially when you really try and unpack the actual issues. Then go on and say, well, what are some options? If it is those 3 nights, is it plausible? Are you able to do it with your work circumstances? What is your child like? Are they shy and a little bit clingy, or are they really extroverted and out there? So a lot of these things really need to be thought about by parents, which a lot of them don't. They just go straight to, oh, the law says. So think about those things. And again, what's good for you, every family is different, but just nut it out, the issues. If you can't do that with each other, mediation is usually the first port of call. And I like mediation because it's not just you and them. At loggerhead, you have this third party, which hopefully are good at what they do and will be able to either rephrase what you're trying to say. Because a lot of the times I find that you can say something to your former partner, they will say no and cut you off, whereas someone else that they hardly even know will say it in the exact same terms, and I'm like, oh, I never thought of it that way. Very frustrating, but it is typical. So that's why mediation is really great. Now, if mediation does fail, then you will be given a certificate which you can then go to court. Court is not always a preference, but sometimes it's an inevitability simply because of the distance apart that you both are. Again, before you do mediation or go to court, it's always good to get some specific advice about your family from a lawyer or even a psychologist and be guided by that, because it may be that, like I was saying before, that one option that you're concentrating on, we can open up the options and get you thinking a bit more about other things that could happen in the short term to hopefully produce an outcome that you're wanting in the long term. And if you can afford it, preference is that mediation is private, only because they've got more resources, they can get in more quickly. The government organisations, they're heavily used, so there's a fair bit of a wait. Sometimes you can wait up to 6 weeks, 6 to 8 weeks before you get in for your intake. The other party will have to do their intake, and then it may be a couple of weeks after that before you actually have the mediation. So it can drag things out, whereas private mediation, you can usually get in within a week or two. Now, specific issues. So this is basically exactly what it says, specific things, specific issues that will crop up in some matters, not all, but as children grow up, you probably will find that a lot of these you'll touch upon. Again, I stress, no one family is the same, and no one answer will be right for all families. And it comes back to those options as well. Now, first thing, location and recovery orders. So what are they? Well, a location order is if you don't know where the other party and the child is. This location order, if made, it will go to a third party, such as Centrelink, a school, police, asking for the child's contact details. That actually won't be given to you. It'll be given to the registrar or your lawyer. Registrar if you're self-represented, lawyer if you have a lawyer. And then there's also recovery order. So this is used to return a child wrongfully taken or retained by a person. I've just gone through that. How to get it? Unfortunately, these ones you do have to go to court. They're generally made in the Federal Circuit Court. Now, I haven't touched upon this, but there's two different courts. You've got the Family Court of Australia and you've got the Federal Circuit Court of Australia. The Federal Circuit Court of Australia is usually your workhorse court. That's where most matters will be initiated or applied for. The Family Court is for more complex matters. So probably about 80 or 90% of the time, you will file in the Federal Circuit Court. It's a lot quicker court. There's more sittings, so things will get resolved a lot quicker. And I use air quotes when I say quicker because court can sometimes still be a little bit slow. So the documents that you'll need to file, the initiating application, affidavit of view, and a notice of risk. There's a mandatory form and an affidavit of non-filing of basically the mediation certificate if there's urgency. Those forms are all on, if you go to the Federal Circuit Court website, they're all there in Word format. Now, the type of information you need for your affidavit, which is your statement. So that's basically you saying to the court, these are all the relevant facts as to why I want you to make a location and recovery order. So I won't go through each of these because you will get a copy of these slides, and I'm just very conscious of time. But here has, and those red parts there, they're very important to make sure that you specifically do put it in your affidavit. With your affidavit, it's a skill in drafting. Don't put a lot of emotion. Stick to the facts only. The court's not going to be swayed if you put in a performance in your affidavit. They won't care about that. They want facts. They want to know legally what information they need to be able to make that order for you. So this is a list. It's not exhaustive. There's other things that may be at play depending on your matter, but these are the bare minimum things that you need to put in if you need to get a location or a recovery order. Now, relocation. So if you do want to relocate, they're no different to any other care arrangement application or discussion, only that the distance is a lot greater usually. So the relevant best interest considerations, because remember I said there was the 2 primary and then you've got a whole list of about 14 other ones. These are the relevant ones when it really comes to a relocation. So the benefit of the child of having a meaningful relationship with both of the child's parents, the likely effect of any change of the child's circumstances, of any separation from either of his or her parents or any other child or person, the practical difficulty and expense of a child spending time and communicating with a parent, and any other consideration. You really have to have a well laid out plan if you're wanting to propose a relocation. It's not good enough just to say, oh, we're in Townsville now, I want to relocate down to Melbourne. Will you allow it? The fear in most of us, because that has absolutely no plan, will be, no, I don't know, no. What you need to do is you need to sit down and think, well, what suburb in Melbourne would I be in? What sort of school would I be enrolling Tommy in? What sort of time will the other parent have, both whether it's Skype, FaceTime, in person? How are we going to fund that? I've had matters where people say, oh, listen, I can bring Tommy up every month. Well, who's going to afford that? So you need to look at the practicalities of things. So it's not enough just to say on a whim or even, oh, my family's down in Melbourne, therefore I want to relocate. You really have to be specific in your case plan. I'm not saying to get an apartment or a house and sign a lease, but put into some thought, have a look, are there units or houses in the area that you want to live in? How much do they cost? Where is your income coming from? What sort of schools are down there? All those sort of things really need to be thought about before you just throw it out there that you want to relocate. Now, the reasons for relocation, there's many. The most common are that you want to move closer to family, to return to a previous family location, or if there's work for yourself or a new partner, if you've got a relationship with a new partner, living costs or accommodation are too high, lifestyle or health, training or study, or to escape violence, control or harassment. So there's the most common reasons. You don't have to have a compelling reason. The case law is very specific about that, but you do need to properly plan things out. So the parenting wanting to relocate. So here's just a couple of things that you need to think about. So the best interests of the child, so refer to that previous slide. How the move is a positive one, a consideration of the competing claims or proposals. So be prepared to have, if the child's allowed to leave with you, but also if the child's ordered to stay, are you going to stay? Are you going to leave regardless? And if you leave regardless, what time are you going to be spending with the child? You need to have that alternative proposal because the court will make a decision one way or the other. And if it's the other way, you want at least some form of proposal that you would be comfortable with before the court for them to hopefully make. It doesn't show a weakness in your case. It shows that you've properly considered things. That's one thing that someone once said to me, oh, but I don't want to show a weakness that, oh, well, if the order's against me, I'll be okay with something else. That's not what it says. It says to the court, the control is totally in your hands, Your Honour. I understand and I've been advised that it could go either way. If it doesn't go the way that I want, then this is the alternative. And you'd address the same things, you know, the difficulty or the impact on your relationship with the child. The shoe certainly fits both feet. When, where and how the proposed move, so that's what I was saying before, properly plan these things out. And whether the other parent can relocate as well. There's been a couple of cases where the court has asked that of the other parent. What are your ties to the current town? Are you able to relocate? Can you get a transfer with your current company? Those sort of things. So be prepared to delve into that with the other parent as well. Now, oh, here you go, some more stuff. How long the moving parent plans to stay away in the new location. So, for example, if you're in the Defence Force and it's every 2 to 3 years that you're going to be moving around, you need to put that in. Again, thinking of proposals, you've really got to think of things. Don't just go in, like I said before, with just, I want to relocate. So have a read of that slide, and you will get a copy of these slides. Now, the parent that's opposing the relocation, so the parent that doesn't want the child to leave, you need to think of things such as the strength of the current relationships and their inherent positives. The younger a child is, the more difficult it may be for the child to relocate, simply because the strength of the relationship may not be there, and a relocation may actually hinder the progress of that relationship. So you really need to concentrate on, if there has been periods of time during the relationship that the other parent has been away, well, how did the relationship with the child survive that? So those sort of things may be something that in your relocation may or may not work. So you really need to think about that. The uncertainty of proposed new arrangements. I've had cases where there was just no detail. So it was very difficult for the court to consider that the relocation was in the child's best interest. So you really need to think of the detail, and if they haven't, then that's a pressure point that you can use to say the court's not going to make it, it's uncertain. The loss of time, the dislocation from the child's current circumstances, so friends, schools, extended family, those sort of things. Think of proposal again for if the child's permitted to stay with you in the same town, or if the child does get ordered to relocate. So you both really need to be thinking of both sides of it if you can't come to an agreement. When can relocation work? Now, this is the big thing. A lot of parents will come to me and say, oh, I just hate them. I hate that other parent. I just want to relocate. They're making my life difficult. Alarm bells will automatically go off in my head, because it may be that the communication is not great or even good, which will hinder a relocation. The court will not like to order a relocation if you can't communicate. So if at the moment you're not having great communication, work on that. You really need to work on it. The more you can communicate, the better it is. The more time that the other parent can spend to form that bond, that's also good as well. Do not think, oh, that's going to hinder because they're going to have a great bond and the court's going to say, no, the child shouldn't relocate. Think about it this way. If there's not a great relationship with that other parent, the court will more than likely say, well, listen, we need to get this relationship a lot better so that it survives the relocation and the distance. So think about that. So if there's frequent, regular, flexible and conflict-free communication, then that will work. If there's regular face-to-face visits, whether in the home of the distant parent, and that's the other thing. If you're going to be moving, and I'm using Melbourne only because it's the furthest point, or Perth probably is, along the East Coast, but if you're going to relocate to Melbourne, will the kid come back up to Townsville, or will the expectation be that the other parent come down to that new location? So all these things need to be thought out. When will relocation not work? So if there's poor communication, if there's been exclusion of one parent from decision making, if there's inconsistent or tension-filled communication, text, I hate text, even emails starting to become a knee-jerk reaction because we all have it on our phones. Slow it down and just think of things, because if you're doing that, relocation won't work. Negativity about the other parent, if there's infrequent or irregular face-to-face visits, usually that's if it's not being allowed by the parent that wants to relocate. Combination of relocation with family violence or child being aligned and rejecting a parent. The catchphrase here is usually parental alienation. People talk about. You've got to be very wary. You don't want to look like, listen, you've put all obstacles in place and the other parent hasn't been able to spend time with the kid, but, oh, court, I want you to allow me to relocate. So you really need to have great communication, or even just good communication. You need to include that other parent in decisions for the child. You need to make sure that you're allowing contact provided the child is safe. So have a read through those slides and really take it on board. Usually you won't be allowed to relocate if it's terrible communication or you're stonewalling, the other parent. Now, changing a child's name, I'll just quickly go through this. There's no specific provision in the Act dealing with child's name. It is a major long-term decision and therefore would need to have the consent of both parents or a court order. Unless you have an order for sole parental responsibility, in which case you can go ahead and change the name yourself. If you cannot agree, you will need to apply to the Federal Circuit Court for an order, either allowing the name change or opposing the name change. Again, mediation must first be attempted, as with all kids' issues, And these are the documents that you'll need to file there on that slide. Again, if you go to the Federal Circuit Court website, those forms are all there, blank, and in Word format for you to complete. Now, for your affidavit, these are the type of things that the court would look at. So the best interests, the short and long-term, and sorry about the spelling mistake there, the short and long-term effects of any change in the child's surname, any embarrassment likely to be experienced by the child if its name is different from that of the parent who they reside with or have the day-to-day care of the child, any confusion of identity which may arise for the child if his or her name is changed or is not changed. It goes on, the effect which any change in surname may have on the relationship between the child and the parent, the effect or frequent or random changes of names, and it goes on there. So have a look at those slides when you do your affidavit or your statement. Again, your affidavit is basically all the evidence or the facts that you're giving the court to say to them, on the basis of all this, please make the order that I'm seeking. So all these things in these two slides are the things that you need to put into your affidavit or your statement. Now, DNA parentage testing. There's a fair bit in the overview of it because there's some presumptions of paternity and usually they will come into play, especially when there's child support. There's ways of how to rebut the presumption, applying to court for DNA parentage testing if the other parent won't agree. And then I also talk about if someone doesn't make a child or themselves available for DNA parentage testing, what can happen, the different kinds of declarations which you do need, usually for child support purposes. Now, because of timing, I haven't gone through those specifically, but I do have a blog on my website, and I literally have gone through each of those things, but I also have put in templates and precedent orders, specifically if you did need to go to court. So it's all there in that blog. So if DNA parentage testing is an issue that you currently have, that blog gives you everything you need to be able to get that sorted. Now we move on to a little bit of a lesser known thing, childbearing expenses. So what is it? So the father of a child who's not married to the child's mother is liable to make a proper contribution towards the maintenance of the mother for the childbirth maintenance period, which we'll get to, the reasonable medical expenses incurred in relation to the pregnancy and birth of the child, and any expense in regard to the death of the child or mother if death does occur as a result of the pregnancy or birth. So what are fathers liable to pay? The reasonable medical expenses and any expense relating to the death of the child or mother, which I sort of dealt with in that other slide. Now, how long? Now, this is the child maintenance period. So it's 2 months prior to the day the child's due and 3 months after the birth. So that period can be extended if there's these three circumstances. So just be wary that there is a 5-month period where if the father is not helping out at all with the expenses of the birth or leading up to the birth and after, you can actually get them to pay. In a recent case, the father was ordered to pay the mother $14,000, and that was on top of what the father had already paid of $3,200. So he thought he was doing the right thing and paying her a bit, but the court said no, there was additional expenses that he should have been liable for. Now this is different to child support, so be very wary about that. Adult child maintenance. So this again is different to child support. Now child support's up to when the child is 18 or finishes secondary school. Adult child maintenance basically can extend beyond that. So it can be ordered if the kids are over 18, if financial support is necessary to enable them to complete their education or because of a mental or physical disability. How do you get it? Well, it must be by court order. It's not through the child support agency, and that court order can then be registered with the child support agency. You can do it by consent orders, but it needs to be done in an order. It can't just be an agreement between you both. I mean, you can get an agreement between you both, but that's not enforceable. It's not binding. So if the other parent does do a backflip, you'd have to get the order. So here on this slide is just what is considered. So if adult child maintenance is something that is an issue for you, these are the things that need to be considered. And again, it's that initiating application, your affidavit in the Federal Circuit Court. Then we go to overseas travel. Now, With this, there's a little known section of the Act that basically says you can't take a child out of Australia if there's a court order or proceedings are pending for the making of a court order, unless you have the consent in writing of each of the parties or it's pursuant to an order of the court. So I will get some people that when I say, oh, listen, let's put in about overseas travel, oh, no, don't worry about that. But what they don't realise is unless you get the other parent's consent in writing, other jurisdictions may pull you up in customs. Each country is different, so it's always good to err on the side of caution. And the other thing is if a child is going overseas with a grandparent or another family member, there's additional documentation that you should be getting from both parents as well to assure that some overseas country doesn't think that there's a kidnapping issue, which has happened. What the court will look at, so basically put it into this perspective or this example. If you're wanting to take the children over to, say, America in the Christmas school holidays, but the other parent doesn't agree, then you can make the application to court, and these are the types of things the court will want to look at. What is the length of the proposed stay? How genuine is the application? So if you're an American citizen and you want to go back over to America and you've booked one-way tickets, alarm bells might be going off in the sense of, are you going to be staying over there and holding over and not returning the kids? The court will also look at the effect on the child of not having contact with the other parent, any threats to the welfare of the child by the circumstances of the proposed environment. What that means is, say if you're going to a country which has a red alert and it's a war-torn country, the courts more than likely won't allow it because there's too much of a risk to the child. The degree of satisfaction of the court that a promise to return will be honoured. And what that means is sometimes the court can order a surety, so monies to go into an account which will stay there and will be returned to you if and when you return to Australia. If you don't return to Australia, those monies can be released to the other parent so that they can then fund any legal proceedings that they may need to in that other country. That's usually only relevant when it comes to non-Hague Convention countries. So that's basically countries, and I think I've got it here, and that's one thing that the court will look at, whether the country of travel is a signatory to the Hague Convention on Child Abduction. So basically Australia Consulate has agreements with certain other countries that if children from Australia are held over and not returned in that other country, the consulates will talk to each other and usually they will deal with things. Obviously you'll need to be a part of that, but it's a lot easier to get the children back. There are, and I won't go through this specifically today because there are a fair few other things that the courts need to look at if it is a Hague Convention country. So there's a couple of other things there, so have a read through those slides. Again, I'm just conscious of time. Now, breaches of orders. So if you've already got an agreement, you then put it into orders, whether by consent or had any court made, they're binding and enforceable, okay? If someone doesn't do what they're supposed to do, that's called a breach of the order. If you're wanting to breach the other parent, you're basically asking the court to punish them. And that's done in an application contravention. If you're just wanting the orders to be followed, that's usually either an application of case or an initiating application to try and enforce the orders. But the application contravention is if you're wanting the other parent to be punished. It is a quasi-criminal proceeding because, again, you're asking for the other parent to be punished. The court's not obligated to punish the other parent. We call them the respondent. But punishments can range from good behaviour bonds right through to fines and imprisonment in the really repetitive and serious cases. The first stage I always look at when there is being a breach is, well, should the parenting order need to be changed? Is it not working in its current form? Because sometimes it's as simple as that. A changeover is supposed to be 5 o'clock on a Wednesday, but the other parent's routinely there at 6 or 6:30. It may be that 5 o'clock's not working. So again, it's thinking outside the square. It's not just the one option, they need to be punished. Let's think of 2 other options. Always go for 3. How do you apply? Mediation is required because it's to do with kids. But if you've done mediation, you can't come to an agreement, you do want to continue, those are the documents. Again, it's in the Federal Circuit Court. The other parent, the respondent, doesn't need to file a response or even an affidavit to what you're alleging. However, it's good to have one ready if it does go further. But what do you need to show? So what do you need to show? And this again is in your affidavit, so your statement. You need to show that the person was aware of the order and the obligations. A lot of the time, if it's done by consent, then they've got their signature, so they're aware of it because they agreed to it. If it was done by a court order, then you look at, were they in court at the time that the orders were made? Did they have legal representation? All those sort of things. Then the breach must be proved. So you need to show that there was actually a breach. If the person that has allegedly breached the order, they may argue that they had a reasonable excuse, and that's the only defence to a breach. And what I mean by that is, say, Tommy was meant to be at changeover at 5 o'clock, but he didn't show up. Therefore, that other parent, yep, they're in breach because they didn't show up. But they may have had a reasonable excuse because little Johnny had an asthma attack and was up at the emergency department at the hospital. Hopefully, you'd be notified of that, but that would be a reasonable excuse. So always look at those sort of things. And usually, when there is an alleged breach, I normally write or talk to the other parent and ask them, you know, the orders say this, you didn't do it. Was there a reason? And you take that into account only insofar as I need to consider, is it reasonable? And if so, then you might not want to waste your money and time and energy in breaching that other parent. But if it's not a reasonable excuse and it's just them, you know, being antagonistic or whatever, then you should lead evidence contradicting that, okay? So that's what I was just talking about. They may have a reasonable excuse to do so. Yeah, each case will be different about the reasonable excuse. I can give you a whole heap of examples, but it's best just to, if it's specific to you, just get that specific advice as to whether it is a reasonable excuse. Now, the possible outcomes if there has been a breach of a court order. One, the breach isn't proven. So basically the court says, no, on the evidence, it doesn't look like there has been a breach. You may get a cost order against you. So it's very important because it is a quasi-criminal proceedings. So it is very important that you do get some legal advice before just jumping in, or at least consider what you're doing seriously. Number two, the breach is proven, but there is that reasonable excuse. So the court may say, yes, there has been a breach, but there was a reason for it and it was reasonable. Third, there is a breach, but there's no reasonable excuse. And the court will then categorise number 3 and 4 as either a less serious breach or a more serious breach. And that will determine what sort of penalty is put into play. Now, regardless of whether the breach has been proven or not, the court can still change a parenting order. And if there's a subsequent parenting plan, then the orders may not be enforceable insofar as they're inconsistent with that later parenting plan. Now, that may sound a little bit strange because you'll be thinking, but I've got a court order. But if you have a court order, then you go to mediation or you come to an agreement and you do it up in a parenting plan, which is signed and dated by you both. Whilst that's not a binding and enforceable document, it can change those orders. And that's the purpose of the parenting plans, to make it more efficient and easy for parents to come to alternative agreements. So don't be thinking, oh, well, we've got a parenting plan after those orders, but I want to revert to those orders and they're not playing ball, I'm going to breach them. You will have no joy and you'll more likely get a cost order against you. Alternatives to breaching: amend or change the orders. Always look at what the underlying issue is. Just because they're not following an order, think outside the square and go, why? Is there a reason why? Don't be thinking, oh, I don't want to do all their work. At the end of the day, you're getting frustrated by the breach of the orders. Is there another way or a better way that the orders could state things because of a change of circumstance or whatever? Then maybe that's what you need to be doing, amend or change the orders. Okay, now we come to the pointy end of the webinar, agreements. So how do you come to an agreement? There's about 6 different ways as far as I'm aware. You've got the kitchen table. It doesn't have to be the kitchen table, but it's basically where you both talk about things and you come to an agreement between you both. Second one is mediation, where you kind of want to talk to each other, but you just find it difficult to communicate. A mediator can then assist. That can either be with lawyers or without lawyers. Then you've got number 3, lawyer-based negotiations. I don't like this one. I'm a lawyer, I know, but I don't like this one. It's costly. A lot of the times things can be lost in translation. My preference is, if you are going to engage a lawyer, either do roundtable conferences so that you've got a bit of an agenda set up so that you know what you're talking about and you get a bit more out of it. Similar to a mediation, but you, instead of just having a half-day or one-day mediation, you can do it over a course of time so that you're not as stressed and you're not as anxious and you're not as exhausted, I suppose. Or with lawyer-based negotiations, it's probably not an or, but you do it yourself if the other parent's got a solicitor, but we can actually shadow you. So we can be in the shadows and just help out and give you some guidance, but you go off and do everything. So you'll need to have a degree of, I suppose, confidence to be able to do that, but also time, because you'll be pretty much doing a lot of my job. Number 4 is collaborative law. This one is where you contract out of going to court, and you basically say, we're not going to threaten and we're going to stay within this process and come to agreements. That is usually done with solicitors, and you also have psychologists involved to help out with the psychology of your children and what's best for them. And it's also done in meetings. We call them 4-way meetings. I do find that the clients are more in control of that process, whereas with the lawyer-based negotiations or even court, the solicitor is more so in control, or the court is more so in control. So collaborative law, it really is you guys talking, assisted by your lawyers, but it's where you guys get to shine. Arbitration, a little bit less known area when it comes to family law, but it's basically, I say it's similar to court in the sense that you both pay an arbitrator instead of a mediator. An arbitrator, you'll still give them certain documents. They will then consider things and make a decision, and that decision is legally binding on you both. That can actually be done quite quickly. And when I say quite quickly, I mean a couple of months to 6 months, whereas litigation, the last one, that can take years. Yeah, it will be 6 to 8 weeks before your first court event. That's going to be a non-event because the court's going to have about 20 or 30 other matters before it. You'll be then put off to another court event, which is either a child dispute conference or something like that, or even a family report interviews. Then you'll have another court event, and then if you can't come to an agreement, then you'll be set down for a trial, and you'll be sitting in that pool waiting for about 18 months. That's on top of the 6 to 9 months that you've already been in the process. So preference is to avoid litigation if you can. Sometimes you can't. But it is really knowing how to navigate through the court system. So you may need to get guidance from a family law specialist to know how to guide your way through. Now, agreements. So there's a couple of different ways. You can have parenting plans. Now, that's only for children's issues. It's not binding or enforceable. It can easily be changed in the future if you have an existing court order. The parenting plan can vary the court order, as I said before. It just has to be in writing, dated and signed by you both. Now, a lot of the mediation organisations will do up parenting plans. That's great if there's a degree of trust and communication, but if not, then it may be that they just won't follow it. And because it's not binding or enforceable, you're sort of left with this lovely piece of paper. The next one is an application for consent orders. Now, this is one where neither of you will go to court, but if you've got an agreement at mediation, you can actually do it up in this document. And again, this one's actually on the family court website, just to mix it up, not the Federal Circuit Court website. It's the family court website. But if you Google application for consent orders, Google will bring it up, basically. Can be for both property and children, or one or the other. It is binding and it is enforceable. You don't actually need signatures witnessed by anyone. It's got this thing called statement of truth. Still don't quite know what it means, but it just means that you don't need a solicitor or a justice of the peace to witness your signature. So you can actually do that on the kitchen table, sign it both, and lodge it in court. So it can be very cost effective. There is a filing fee, which I think may be $160 or something like that. And again, it can be accessed through the Family Law Court website. So that is it in relation to the webinar. So we have pulled it up on time, so that's good. So where to from here? So this is a lot of information that you just got. It probably was done on fast forward simply because I tried to just touch upon each of those things that may be relevant to you and some may not at this moment in time. But the first thing to think about is just, well, we say the 5 Ps, or as a colleague says, the 6 Ps. Proper preparation prevents piss poor performance. Yeah. Think about things. All those slides that I've just showed you, read over them, the specific things that relate to you, the workbook that hopefully you've already received, if not you will receive. Have a look through that. Don't knee-jerk react and think, well, this is one issue, therefore this is the only option to deal with that. Open your mind. And again, think about what's workable and what developmental stage your child's at. There's no point in pushing a 1-year-old, 2-year-old, 3-year-old into 7 days on, 7 days off, because it may backfire on you and the child will have some behavioural issues. And thinking outside the square, speak to your former partner. You're co-parenting now. If you're finding it difficult to communicate with them, go get help. It's got nothing to do with you having an issue. But if you get some counselling or some guidance from a psychologist as to how to engage that other parent, it's going to work wonders in the long run. And it may be that straight off the bat it's not working, but if you keep at it and you're consistent, you're respectful, and you're the bigger person, usually 8.5 times out of 10, it will work out in the long run. The workbook, mediation, and see a solicitor just to get some specific advice. Okay, it doesn't have to go anywhere from there. You don't have to retain the solicitor, but at least just get some initial advice to say, listen, these are the specific issues, these are the things I'm thinking about. What else? What you know? Or if you just go and say, this is the issue, I don't know what to do. They'll be able to help out. So that's pretty much it. I have a slide for questions, but as we're just going over the finish time, what I'd invite you to do, you will get an email hopefully tomorrow. Respond to the email if you've got any questions or if you need anything. But otherwise, what I'm going to do is I'm going to wrap it up there because we are out of time, and I thank you all for attending, and hopefully you've got something out of this. But have a look at the emails that you get after this, because there is a special offer within those emails. So have a good day and a great rest of the week, and over and out from here.